Good afternoon, everyone, and welcome to today's CPD webinar brought to you by the Recover Compensate Network. I'm Natasha Benson, and I'm delighted to be joined by Mark Traynor and Dylan Blackburn, who will be joining us now. There they are. Who will be leading our discussion on maximising your fees. Before I pass over to our hosts to get today started, just a few bits of housekeeping. Today's session will end at approximately 2 p.m. and we will conclude with a short Q&A with my colleague Neve. So if you do have any questions throughout today's session, please feel free to put these in the Q&A box or at the chat box at the bottom of your screen. The webinar will also be available to download once today's session has finished, and I'll now happily pass you over to Mark and Dylan.
Good afternoon. Thank you for inviting us along to speak to you this afternoon. We were meant to be joining or dealing with this next Friday. However, Scotland played Germany that particular night, and there wasn't any guarantee we were going to be sober enough to seminar at lunchtime. So we're here today, and I think probably first of all, just give you a little bit of background about who we are. We are Scotland's largest law accountancy firm with with 15 qualified law accountants and a total combined wealth of experience of around 350 years. And that's just Dylan. We have a wide experience in all aspects of legal accounting and costs, including judicial accounting, all manner of judicial accounting. Within that, we have specialist departments dealing with clinical negligence, commercial actions, and so on and so forth. We also have a specialist private client department dealing with trust and executory work, and a specialist family law department. So just like many of you, we have niche specialists within the overall judicial accounting and accounting feeing specialism. As a firm, we take a very much a holistic approach to our service, in that we see little point in just producing an account for you, sending it back and leaving you to get on with it. It makes an awful lot more sense for us to get involved in providing general ongoing advice, assisting with and gathering information, clarifying issues, providing advice as cases are being litigated, providing seminars, and so on and so forth, so that as our relationship with you develops, we begin to work together to maximise fee income and judicial recovery. I've left on that slide, and I'm assuming you're going to get past copies of the slides, but I've provided contact details for different departments on the slide there. So I'm going to deal with initially sort of client feeing in terms of business, and crucially how important it is to have a good file, whether that be electronic or paper file. There are, believe it or not, still some of us out there that like hard copy file. And then we'll move on to maximising judicial recovery. I would give you a kind of general bit of information on where we're at in relation to taxation processes and so on and so forth. And then Dylan's going to deal with some of the more significant issues in relation to judicial recovery, and in particular, sanction for counsel in the Sheriff Court, certification of expert witnesses, and doing whatever you can to avoid contract count. So, agent-client feeing. I'm pretty sure that most of you will have experienced the good client on the left and perhaps the not so happy client on the right. And I suppose to a large extent our efforts are geared towards trying to avoid that phone call from a client irate at the size of your bill, or the manner in which they're being feed. What are the Law Society guidelines on feeing? Essentially, the fee must be clear. Your terms of business must be clear as to how the client is going to be charged. It must specify hourly rates and hourly rates for each grade of fee earner if you're going to have multiple grades of fee earners charging at different hourly rates. They have to clearly state whether, in addition to the standard fee, you're also going to charge for posts and incidents, which is very much a historical charge to reflect the likes of postage costs, which these days are few and far between. But this is the Law Society guidance. Reference should not be made to additional fees being charged to reflect elements of complexity, responsibility, or novelty. The basis of the calculation of the fee should be clear, accurate, and measurable. If commission is to be charged in addition to an hourly rate, this needs to be specifically referred to in the terms of business letter, otherwise it cannot be charged for. Now that's quite a move away from how we used to fee in the olden days, the according to circumstances basis, where we would undertake the arithmetical calculation and then either add something on or take something off to reflect a balanced view being taken as to what a reasonable fee might be for a piece of work. So now you have to make sure that your terms of business are absolutely crystal clear as to how you're going to charge the client. And deviation from that can result in all manner of difficulty come taxation and beyond in the event that fee requires to be challenged. Looking specifically at executives and private client work, to an extent, your terms of business become more important than ever. The question is, who is actually ultimately paying your bill? Yes, you've been employed by the executors. However, ultimately, I suppose it was really the residuary beneficiaries or beneficiary that is paying the money on the basis that it's coming straight out of the estate before the balance of funds is passed on to the residuary beneficiary. So from that point of view, the residuary beneficiary also potentially has an interest in the fee that's going to be rendered, which in turn creates additional points of challenge, if you like, from additional individuals when you're rendering your fee. Insofar as charging for value, risk, and responsibility is concerned, you therefore need to, at the outset, either set out the hourly rate you consider will be appropriate for that particular piece of work. That doesn't necessarily need to be your standard hourly rate. You could set a higher rate in a more complex or higher value estate. Often at the outset, you don't necessarily know how complex or how high value an estate is going to be. Or alternatively, you can factor into your terms of business charges for commissions, which will, to a large extent, reflect the value, risk, and responsibility. Commissions generally will only be charged on movable estate, not necessarily heritable estate. And that's what some of our clients are doing now, is including within their terms of business almost a commission element, if you like, what we used to call an investigation fee. It's a commission element on the total value of the estate given up for confirmation. But these are the sorts of things that we as a firm we picked up a lot. We've started doing a lot more executive and private client work, and any new client tends to come in, and we have a sit down and a discussion about terms of business before we move matters forward. There is also I do a bit of work through the Law Society in relation to complaint, including fee and complaints. And the last thing anybody wants is for the Law Society or the SLCC to become involved in a client dispute over a fee, or indeed a dispute from a beneficiary. What our department tend to find is that charities can actually sometimes be the most difficult in challenging fees when it comes to executory estates. Moving on then to family law, again, clear terms of business, the Law Society guidelines are set out. With family law, and certainly private client family work, there tends to be probably more challenge because the bill is being paid out of the client's own pocket. And particularly in this day and age where the economy is not maybe what quite used to be 15 years ago, we're seeing more challenge than we maybe did in the past. One way that a lot of our clients overcome the potential for challenge of a large fee is to render fees on a regular interim basis. Some even once a week, but certainly once a month for most family law clients. And that way, 2, 3, 4 months work with a bill of £30,000 or £40,000 doesn't come as quite as much of a shock. A lot of our clients also will highlight in their terms of business that they will send their files to an independent law accountant to assess the reasonable fee. And that creates that element of distance between the solicitor fixing the fee and the client having concerns that it's too high. We also, as part and parcel of our service, would assist in relation to justifying the fee if there was any challenge by the client. We've also noticed in family law that there has recently been a much greater increase in judicial awards between parties in family actions. It was always the case in consistorial cases that judicial awards of expenses were few and far between, and it was only in quite extreme cases. But that is no longer necessarily the norm, and we're seeing an awful lot more judicial awards between parties. Unfortunately, a year or two back, our firm made the decision that it was no longer financially viable for us to maintain a legal aid department per se. So we don't necessarily do legal aid work, albeit we still do have specialists in legal aid to be able to provide advice. So our function really, our client base really is private client and judicial work. This is probably the most important lesson of all, I suppose, is how you look after your file, because that ultimately determines either how much you can charge your client, how easy it is to justify the fee to your client, and in the instance of a litigation, the extent to which you can recover costs from the opponent by way of a judicial account. So we see fairly regularly potential for significant loss in fee income because time is not being recorded properly, or time is not being noted on file notes. Documents are coming in which clearly will require to be considered, but there is no file entry or time record to determine how long it took to consider that particular document. Equally, from a judicial point of view, the lack of that sort of information results in a reduction in recoverable cost on the opponent. In instances where you are accepting judicial expenses, again, that's you that loses out. In a situation where it is your client who is paying privately, the judicial recovery is effectively to reduce their liability to you for fees. And in the event that you're not recovering the maximum you could for the client, there is again potentially the scope for a complaint. We often will be asked by solicitors' firms if we can justify a fee that they have rendered to the client without our prior involvement. And very often in those instances, when you go through the file, there is insufficient information on the file to be able to justify the fee that's been rendered. We have seen situations with time recording systems, for example, where there are multiple entries on the time recording for various items of work, but with no narrative to reflect what is actually being done at each stage in the time recording. And that creates a situation where the fee cannot be justified unless the solicitor involved is able to put a narrative to each element of work, or the associated file makes clear what each individual item on time recording is. The other issue that has become, well, I don't think it's as concerning as it maybe once was, but with the advent of GDPR, it becomes even more important that your file contains all and only relevant information in relation to the case in question. Now, frequently, but not as frequently as before, we do find bits and pieces of correspondence relating to another file on the file we're working on. And that you really kind of want to weed that out as far as possible. So some tips. WIP, your electronic time records, work best probably as a guide or a management tool. There are a lot of firms who are now charging on a time-only basis, which has its own, from my point of view, its own concerns. I think it's good practice to be reviewing your time records when preparing or assessing a fee for a particular period, to ensure that you're not trying to charge for something that is possibly not chargeable. As far as possible, both in terms of private feeing and judicial work, WIP records should be substantiated with appropriate file notes. The other issue is charging purely on a time basis can create more difficulties with a client than not. Now, that's not necessarily the case so much in commercial situations, but certainly where an individual's paying a fee, they tend to be much more keen to scrutinize where you're charging on a time basis. That creates a situation where you can end up rewarding the inefficient. And that creates a much greater scope for an auditor to reduce charges. Whereas if you charge per page of a letter or per sheet of a document, there is a factual basis for the particular charges and the particular work that's been undertaken, which in turn ensures that the fee can be much more easily justified. When you are recording time, particularly in an electronic case management system of the likes, it's crucially important that you differentiate between different types of work. So, for example, unless you're charging purely on a time basis, for example, if you have drafting writ corresponding with the client and 3 quick telephone calls, all of these different items are charged on a different basis, and therefore globalizing them as one claim entry is not necessarily helpful. Where work undertaken is either unusually complicated or takes an unusual amount of time, it's very helpful to put a note on your file note to explain why it took the time it took, or what the complications were, so that when it comes to having to justify the fee or justify the entry within a judicial account, the information is readily available and able to be passed to an auditor of court. It's also always helpful to, particularly for things like meetings, consultations, pre-trial meetings, court attendances, to include start times and end times. We very frequently get challenges in judicial work where the defender's file note or the opponent's file note doesn't necessarily match the times included in your own file note, as a result of which the auditor tends to have to take a view somewhere between the 2 times noted. Where you include a specific start time and a specific end time on a file note, generally speaking, in our experience, the auditor will go with your file note rather than file note of an opponent, which only includes a global block of time. In your time recording, be careful of using words like research, refusal of incoming emails, or administration. These are terms where certainly historically auditors have tended to look at those items as being non-chargeable to a client, and certainly non-chargeable between parties. The reality is, of course, that to undertake a piece of legal work, we can't possibly know everything. There is a need to look at authorities. There is a need to look at prior decisions, legislation, to be able to deal with particular issues. But use of, say, a phrase like consideration of issues arising and reviewing authorities is likely to be recovered without any difficulty, whereas researching tends to suggest that you're educating yourself, allegedly, and therefore is not considered to be a recoverable charge. We're going to kind of zip through a wee bit more. We're going to kind of move on to judicial recovery a little bit. With judicial work these days, it's important to look to properly investigate and prepare your case at the outset. And what McPhail says is in relation to precognitions. It's important that precognition should be taken at the earliest opportunity in order to ascertain important facts with accuracy at an early stage. Take advantage of the witness's recollections before they begin to fade. It should contain exhaustively all the facts of the case, so far as the witness knows them, with all the circumstances fully detailed and with complete accuracy as regards persons, places, dates, and figures. So that's coming directly from McPhail. From our point of view, recognitions are one of the most beneficial ways to maximise your judicial account. So, A, from a maximisation point of view, take full and detailed recognitions at the earliest possible opportunity. But B, from the point of view of running your case in the best possible way, that too is the approach you should be taking when preparing a case, particularly one for litigation. Insofar as expert witnesses are concerned, Dylan's going to talk a bit more on that slightly later. But it's important to make sure that you give proper consideration to selection of the appropriate expert for a particular case. And there have been a couple of decisions recently where the courts have determined that the expert actually employed was not the appropriate expert to instruct in a given case. We'll come on to that. In relation to the current taxation programs, it was significantly materially post-COVID or since COVID commenced. Like the courts in general, taxation moved from face-to-face to become, in essence, written submissions with a brief telephone discussion. We have not had a face-to-face taxation since February, March 2022. No, 2020. 2020, when COVID came in. Gee whiz. We have the whole process in relation to points of objection has altered. There's now a requirement for detailed written responses to be put in, which in effect takes a good bit longer than just preparing and attending at a face-to-face taxation. So the cost of taxation has gone up. So far as the auditors are concerned, there have been a number of retirals over the last few years. The auditor of the court session and aspect came into post around the time of COVID. So we have never ever had face-to-face taxation with the auditor of the court session. And that in turn creates a difficulty in relation to having proper discussion of issues at taxation. There's also concerns that have arisen in relation to changes to the judicial expenses rules in 2019 and the interpretation that some of the auditors are giving to those rules. Just quickly, I'll flick the rule on. So the Taxation of Judicial Expenses Rules 2019 states that the auditor is to allow only such expenses as are reasonable for conducting the proceedings in a proper manner. Now that is not massively dissimilar to how the rule was framed previously, but the auditors of court have now taken it on themselves to effectively go beyond what was the taxation process and almost object to the account off their own back in the event that the party does not attend that taxation or lodge their own objections. Some auditors will, even where there is an opposing party to an account, raise their own issues in addition. And that to some extent then totally takes away from the rules of court, which require that the paying party or the party found liable in expenses required to lodge specific points of objection with the successful party's account, not later than 4 working days prior to the taxation. failure to lodge those points of objections should then require that, or should then mean that the auditor cannot take regard and take into account any of the objections taken to taxation. And in the event that they're not lodged timelessly within the 4 working days prior, again, they should be disregarded, except where there has been mistake, oversight, or other excusable cause, in which case it's for the auditor to determine the consequences of that failure. Current experience suggests that the auditor will allow late objections in every case. There doesn't seem to be any distinction at all. It's every single case. If your objections are late, he's letting them in. And that then kind of brings us back to, well, what's the point of having the rule in the first place if it's being relaxed in every single case? One thing we do come across quite frequently with judicial expenses is particularly firms that are not dealing with litigation on a regular basis. In the Sheriff Court now, the 4 months rule applies. So that within 4 months of the final judgment, you have to have your judicial account prepared, lodged, and intimated. The rule is not as strenuous as it used to be in the Court of Session, where the failure to lodge your account within 4 months meant that you did not get your account in and you lost out entirely on your whole award of expenses, or the award of expenses rather, for your client. The rule now allows for you to lodge your account at any time with permission of the Sheriff or the Lord Ordinary, but subject to any conditions that the Sheriff or the Lord Ordinary choose to impose. Now, in our experience, that has tended to be either, for example, you do not recover any costs of taxation within your judicial account, or perhaps there is a percentage reduction to your judicial account. But in terms of that particular rule, it's no longer the case that you are unlikely to get your account in at all, unless the breach is so significant that the court considers that the penalty is that your award of expenses is overturned. Right, I have blathered on long enough. I'm going to pass you on to Dylan to talk about expert witnesses.
Yeah, so the first point, obviously, being Rule 4.5 of the Act of Sederin, whereby it relates to the certification of skilled experts. Rule 4.5 basically states that no charge incurred to a person who has been engaged for the purposes of the application of that person's skill is to be allowed as an outlay, unless, and then goes on to provide the basis for instructing an expert. It basically says that an expert must be certified in terms of Rule 5.3 of the Act of Sederin, which effectively relates to this test of certification of an expert, which I'll touch upon a bit later on. Certification of any expert is of vital importance, not only to assist the action as a whole, but the possibility of not actually recovering the expert's costs from the paying party at the conclusion of the action, should expenses be granted in your favour. So in terms of the court rules, certification must be granted in advance of any letter of instruction being issued to the expert. This is on the assumption that proceedings have been raised at this point. However, if you are instructing experts pre-litigation, it would be the matter of fact that at the point of raising your proceedings, you must move for certification at that point. So this is kind of the main reason that you really have to fully investigate matters as to the correct expert that you wish to be instructed in the action. So you need to do this at the very least of opportunity, and failure to do so could lead to quite major consequences later down the line. For example, if you fail to move for certification of your experts, or proceedings being raised, or a motion during the court of proceedings, you will then have to attempt to move for certification for these experts at the conclusion of the proceedings. However, if you are to do that, you are going to have to provide a reasonable explanation as to why certification was not moved for at the time of proceedings being raised or by way of motion throughout the proceedings. And the excuse of simply, oh, I forgot or it was overlooked, simply isn't going to cut it, unfortunately. And by that point, you're risking all the work of that particular expert throughout the course of the proceedings being lost along with the cost of same. So whilst I do stress the fact that certification must be granted prior to the instruction of that expert, there is a slight exception to this, in that actions proceeding under Chapter 43 in the Court of Session and Chapter 36 in the Sheriff Court, along with actions raised under the simple procedure, then certification can be sought at the conclusion of the action for the purposes of work already done. However, there's still an onus on the agent to effectively justify why that particular expert was instructed and the importance of them and their evidence being provided in the conduct of the litigation. Therefore, it's of significant importance to instruct the correct expert at the earliest opportunity. So actions proceeding under Chapter 42A and Chapter 36A relate mostly to case management, personal injury actions, most clinical negligence cases, along with some catastrophic and complex injury cases, will usually be progressed on this basis. Whilst the actions relate to personal injury, whether by fault or design, the rules, as previously stated, will require agents to seek certification of experts in advance of any work being undertaken. In other words, these PI actions are unfortunately not exempt from the rules. So I know what you might be thinking, in that what if you've raised an action under Chapter 36 in the Sheriff Court or Chapter 43 in the Court of Session, but throughout the duration of the proceedings, it becomes apparent that you will require to remit the action to Chapter 42A or Chapter 36A. In that instance, you will require to move for your certification of the experts at the time of the joint remit. Similar to that, if you've instructed the expert pre-litigation, for example, you would move for them at the point of raising proceedings. Similar with this, as soon as you move for the remit to the Chapter 42A and 36A, you will require to move for certification at that point. Otherwise, again, you're leading to the possibility of losing the work done by that expert and the associated costs. At that point, you will also have to move for, I say, retrospective sanction, which is a key phrase here to be included in your motion when moving for certification of these experts. And that is to basically advise the court and to make them fully aware that you are seeking certification for these experts for all work done previously and for all work moving forward. The question of certification at the time of seeking or prior to any instruction of the expert can be extremely difficult in some particular actions, which kind of leads me on to my next point, which is the refusal of certification. So the question that we come across fairly often is that if you move for certification of an expert during the course of the proceedings and it is refused, and you then go to the court and basically move for certification at that point, and the answer to that is quite simply yes. So in a recent judicial review case we were involved in, the petitioner's agents stopped certification of an expert economist to assist with proceedings. However, unfortunately, certification at that point was refused. But agents for the petitioner at that point fully considered the evidence that that expert was going to provide and the importance of the evidence they were going to put forward to the court at proof if required. So the cost of this expert were in the region of around £25,000. So the petitioner's agents proceeded with the instruction of this expert and obtained an expert report, etc. The case then actually ran to proof, and the expert gave evidence for the petitioner, which the case ultimately succeeded following evidence. And at that point, the petitioner's agent moved for expenses of the action as a whole, along with sanction for that particular expert. And following the judgment from the Lord Ordinary, he in fact granted the certification of that expert and realised the importance of the expert input to the case. So it does show that there are particular occasions where if sanction is refused during the course of proceedings, it is completely down to the knowledge and importance of the agent to instruct that expert in the conduct of the proceedings. So moving on to, as I previously mentioned, Rule 5.3 of the Act of Sederent, which basically relates to the test of certification of the expert. And there's two kind of main factors in the certification of the experts. The first of which is fairly straightforward, in which the person being instructed has to be skilled, which really relates to the expert being qualified to speak to the issues that are being addressed and they're going to speak about within their expert report. The second, which is a lot more complicated in my personal opinion, is that whether the expert being instructed was done so reasonably and proportionally employed in the conduct of the proceedings. So this is a key matter to consider when looking at certification of the experts and the level of their instruction. So this is the first reference of proportionality in legislation in Scotland, and concerns arose that it might open the floodgates to challenges suggesting that employment of costly expert reports may not be proportionate to that of the proceedings. It was and certainly remains our view that the inclusion of the word proportionate simply refers to the sort of expert being instructed and the need to actually instruct them for the purposes of the litigation, rather than the actual cost of the report required to be proportionate to the value of the claim. So, in reality, it was not really process per se. We have had previous cases where, for example, the court have refused to certify a care expert where the care was being provided via family members and therefore it could be easily calculable without the need for the expert input, or where an employment expert was instructed where there was a relatively straightforward calculation to be made in respect of loss of earnings. We've recently had a decision from the Sheriff Appeal Court where they determined that the instruction of an A and E consultant was disproportionate to the injuries sustained by the pursuer, where they considered that a general practitioner should have been instructed to report. However, basing that on what I previously said, interestingly, in our experience, you could get the A&E report cheaper in most cases, certainly not all, most than you can a GP report. So consider that there's possibly a discussion to be had around whether a general practitioner can actually be an expert, other than perhaps in cases where there is a GP negligence affair, and they're speaking to liability or causation issues possibly. So based on the information I've just said, there should be significant importance in taking extreme care and considering all matters of investigations when instructing your expert witnesses. Moving on to the sanction for counsel. So parts of the work on moving for sanction for counsel somewhat intertwined with that of the certification of experts. However, in cases that run in the Sheriff Court and the Sheriff Appeal Court, there's a requirement for counsel to be sanctioned for the proceedings. However, sanction is not required in the Court of Session, as there is an automatic entitlement for you to use counsel within Court of Session actions. So upon the application for the sanction for counsel, you have to specify to the extent at which you're instructing counsel to act on your behalf, whether that be for proceedings as a whole, or possibly just simply part of proceedings, which could be, for example, an amendment procedure or something along those lines. Or alternatively, you can move for sanction for particular points or parts of proceedings, i.e. a consultation on tender, etc., or alternatively, all of the above. So in addition to that, when moving for your sanction for counsel, you will have to specify whether that is simply junior counsel, senior counsel, or in some occasions, both. The basis for specifying what counsel is involved is that if you are seeking sanction for counsel within the Sheriff Court, this would only entitle you to recover the cost of junior counsel. Thus, if senior was involved, you would not be able to recover the cost of their involvement, unfortunately. The granting of such a motion would be, of course, case dependent, based on the point at which counsel was instructed throughout the course of proceedings. So, as I say, similar to seeking certification of experts, when seeking sanction for the proceedings, any interlocutor sanctioning the work carried out by counsel has no effect as to the regards of the work carried out prior to the date of the interlocutor being issued, unless, as previously stated, it is a personal injury action proceeding under Chapter 36, simple procedure actions and Sheriff Court appeals are also exempt from requiring to seek sanction in advance. So it goes without saying again, and reiterating kind of previously what was touched upon in the certification of the experts, that it is vital that when a motion is lodged with the court, when you are moving for sanction for some court, it is vital that you do so by the instruction. Similarly, with the certification of experts as well, if certification sanction for counsel is refused, you are entitled to go back to the court at a later date and seek sanction for the proceedings. But again, you will have to show reasonable cause for doing so. As cases develop, anticipated or not, issues can arise which complicate the case, whereby the sanction either becomes justified or the court agree that the anticipated complications can come to fruition. I think the time is getting on slightly, so I'll try and sift through contra expenses as quickly and efficiently as we can. So any contra award is the last point I want to touch upon before the time matters up, in which contra awards can be somewhat expensive. Sorry, 2 seconds. Sorry. Yeah, in personal injury cases, there's now a protection, qualified one-way or shifting, also known as QUOCs, which provides considerable protection against potential contra awards. To an extent that could be a separate webinar itself, as it is completely complex in our personal opinion. So I won't go into that in too much detail today, but if you do have any questions surrounding QUOCs, we'd be more than happy to answer them at the conclusion of the webinar. So we have seen some situations where contra awards, as you'll probably will be aware, can be devastating to the level of recovery. And indeed, we could provide examples of situations where the extent of the contra award significantly outweighs the expenses awarded to the successful party. These are usually seen on 2 occasions. So the first of which you'll see is minutes of amendment. Generally speaking, the rules of the court find the amending party liable unless there's a specific decision to the contrary. Even when there is an interlocutor allowing a minute of amendment procedure but is silent on expenses in terms of General Principle 2.2, the auditor may still refuse any part of expenses that they consider have been incurred as a result or fault or error on the part of the entitled party or the entitled party's representative. So the most efficient way to avoid such an award is not having to amend in the first place. However, if it is the case that you do require to amend, when moving for the record to be opened up and amended, you will have to ask yourself a couple of factors. Has there been a change in the circumstances after the record has closed, which you could not have been aware of the record closure? In such circumstances, the only way the pleadings be brought up to date is by way of said amendment. Or alternatively, the opponent does not in fact answer the averments contained in your amendment, but uses your amendment to introduce new averments themselves. So on that basis, why then should expenses not be either in the cause or alternatively on a non-expenses due to or by? So, for example, we dealt with a case a few years back now where following closure of the record, it transpired that the pursuer's spouse was no longer able to care for him as a result of which a care package required to be put in place. An expert report was obtained in relation to the future care and provisions, and on the back of that, a minute of amendment ensued, to which the defenders lodged very brief answers. When moving for the amendment, the pursuers offered to concede expenses despite the fact they could not possibly have pled the case prior to the closure of the record. So on conclusion of that particular case, the defenders produced their contra account in respect of £20,000 or in the region of. It included a substantial amount of work, including their own expert reports on care needs, consultations with said expert and the defenders, etc. So the case did proceed to be taxed in front of the auditor. And at the taxation, we objected to the costs on the basis that they did not arise as a result of the amendment but in fact investigations which would have been required in any event to counter the pursuer's expert evidence at proof. We also argued that the terms of the award only allowed for recovery of expenses of the amendment procedure, and as such they were only entitled to recover the costs of the procedural steps in connection with that. So the auditor did suggest, however, that the interlocutor stated had the interlocutor stated expenses occasioned by the minute of amendment and answers, he likely would have allowed the account near enough in full. However, ultimately, the defender's £20,000 account taxed at a sum of, I think it was around £1,750. So the moral of that story particularly is that the terminology of any award of an amendment procedure is key in reducing the ultimate cost of that amendment. So another kind of possible costly exercise is post-tender expenses, which we see on a regular basis. The terms of the rules is that you are entitled to a reasonable amount of time to consider the tender and take instructions in that regard. There's no hard or fast rule as to how long that period may be, with each case being dealt with on their own merits. The closer you would get to a proof diet, the less likely you are to be allowed maybe beyond 2 or 3 days to respond, in light of the fact that you should have all evidence and gathered at that stage and be able to take instructions relatively quickly. So certainly our advice would be that as soon as a tender is received, it should be dealt with kind of as soon as humanly possible, with other work on the case being set aside certainly as much as possible to deal with the consideration of the tender. So earlier in a case, you would likely be allowed maybe between 14 and 21 days, case dependent, of course, by which point any kind of post the 21 days you are raising an expenses argument, which could be had upon the acceptance of the tender. So the way to kind of avoid these post-tender expenses as much as possible is to consider the tender to the best of your ability and provide full and detailed instructions to your client and take instructions in that regard as soon as possible. So failure to beat a tender can lead to some astronomical costs on occasions, and ultimately, on some occasions, wipe out your expenses completely. However, I think we are verging closer to, or slightly running over our time, so I may stop there and we will be able to answer any questions that you may have in connection with what we have said today.
Thank you both for a really insightful discussion today. I'm sure everyone will have taken away so many things, because I mean I can't even count on two hands all the stuff that I learned there. So we do have time for I think one question, Neve. So if we'll pass over to Neve. I think we've got one in the inbox, and we'll get started with that.
Thank you very much, Natasha. So, yeah, we've got one question that we've got time for just now. So, to what extent are you seeing private fees being challenged by clients?
On a relatively frequent basis, to be honest. It depends to a large extent on the nature of the case, the sort of client, to be honest. Probably, I would say family and trust and executory work more than anything else is being challenged. And that's where I think it's really, really important to be able to have somebody independent looking at the reasonableness of the fee and trying to provide the client with some input.
Yes.
Um,
I think
yeah.
that answers it, Mark. Yes. Thank you so much. I think that is all we have time for, but if there are any other questions that have been sent through, we'll make sure to pass
Send
those
them on.
Yes,
Send them
will
on.
do.
We'll speak. I'm just glad that nobody asked the question about whether we should be starting with Lawrence Shankland or Jay Adams, because that's the only one I can't answer.
So no worries. I'll send you over to Natasha now, and she'll wrap up today's session. Thank you very much.
Thank you.
Perfect. Thank you, Niamh. So just a couple of final words before we wrap up. I'd like to thank everyone for joining us today. We hope that you really enjoyed the session. I'll quickly pass over to Mark and Dylan for any final words before we finish.
Thank you very much for having us. Please, if there's any questions either arising from today or just general questions anyway, feel free to drop us an email or pick up the phone, and we're more than happy to help out. Thank you.
Thank you very much. Thanks, everyone. Bye-bye.
Thank you.